Thank you. It's 9 o'clock. This is the regular meeting of Mills County Commissioners Court this Monday, October 11th, 2021. If y'all would join us and stand for the Pledge of Allegiance and a prayer. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Commissioner Williams, would you lead us in prayer?
Dear Heavenly Father, be with us today as we do the business of Mills County. Guide us and direct us in all our actions. Be with all the sick and the ones at home today. Bless this country with some more rain and be with us as we go through this season. In Jesus' name we pray. Amen.
Well, for the record, present in the courtroom on the court are County Judge Ed Smith, Commissioner Jason Williams, Commissioner Dale Parton. Absent are Commissioner Wright, Commissioner Guerin. 3 present constitutes a legal quorum. We also have present in the courtroom the county clerk, the county treasurer, and the county attorney, and our chief deputy. So with that, before we dive into the agenda, first I'll tell you we're going to rearrange it a little bit and deal with some of the business action items before we come back to the quarterly consent agenda, monthly consent agenda with all the departmental reports. Secondly, since we have a large audience here, I want to explain that we changed the court rules a meeting or 2 ago to require that the speakers use the podium and the mic at the front of the room. We were having trouble with people hearing, and the meeting, especially with the Zoom and the YouTube audience, had no sound from the audience speakers. So we now have this podium and mic set up for your use. With that, the second item on the agenda is the minutes of our special meeting October 1st. Has the court had an opportunity to review the minutes?
I make a motion that the minutes be approved as written.
I'll second. We have a motion from Commissioner Williams, second from Commissioner Parton. All in favor say aye. Aye. The minutes are approved unanimously. Okay, let's go down to, we're going to start with item 5 on the initial report from the advisory committee on the subdivision ordinance. The committee's met twice, as you'll recall. We had 10 people agreed to serve on the committee. I don't think we've had most of them, but not all at the meeting so far. In the first meeting of the committee, the committee elected Bobby Roundtree as its chairman, and I would like to introduce Bobby Roundtree and ask him to come up and give us their initial report.
Jason hurt my feelings. I said I'm going to pull this microphone down. So.
You can take it off if you want. I can't make you happy, can I?
Oh, you did. By the way, Jason ran into my fence. The straightest stretch of highway on 574. Jason jumped off the road and hit my fence, but he fixed it the other day. So. Let me first introduce Tommy Ledbetter, John Brown, Bill Malone, Jet Johnson. Those are members of the committee, along with Kerry Harper, Wesley Peters,
Monty
Mike Williams,
Monty Corleone.
and Cal Boyle hadn't been to our meetings yet, and I think you'll be more. Appreciate the time that these guys have put in, and we appreciate the opportunity to do what we can do and help with this.
Mr. Roundtree, I'm sorry to interrupt, but we're having a hard time hearing you.
Okay.
So how close do I need to get to this?
I don't know. See how close you could make it.
Can you hear me now? Jackie?
Yes, sir.
Wow. How about you, Jason? You wanna try to test it a little bit?
Go ahead.
1, 2, 3. 1, 2, 3. Hello, hello. Jackie, can you hear us okay?
Yes, sir, we can.
Okay. Jason?
Yeah.
You just have to set out the audience. First meeting, we met with the judge, excuse me, and the judge had prepared a notebook for us with a variety of information in it. The existing subdivision ordinance, the recommended subdivision ordinance, and then a couple of articles, excuse me, a couple of laws from TCEQ or the local government code regarding planning and water and what counties can and cannot do. And we talked about that for a little while, and then the judge made it pretty clear that he did not want to be a part of this committee's decision and left us by ourselves. And at that point, we discussed several items in the proposed ordinance that we didn't particularly care for, some of the items that we did like, and then we got up on the water. And we determined the water was the most important item as far as we were concerned in this subdivision ordinance. And that's one of the reasons that you have this item on your agenda today. Our second meeting, we felt like we needed some clarification and some lecturing. So we called Gerald Hale to come and lecture us a little bit. And the judge was there for a few minutes, and he went over, I believe it's chapter 230, I believe, or maybe 232 of the state, the local government code, which kind of outlined what the commissioner's court can and cannot do regarding a subdivision ordinance. And we thank Gerald very much for that, and the judge, and it's our intent to stay within those guidelines. We want to do what the court is authorized to do by state law, and that's what we plan on doing. We'll be meeting again tomorrow at 2 o'clock. I believe we're going to meet 1 o'clock. Yeah, excuse me, 1 o'clock. I believe we're going to meet right here in this room. Oh, we're not, Jackie? We're going to meet here in the
Yes,
courtroom?
we've decided to change it from the grand jury room to the commissioner's courtroom.
Okay, we'll meet right here at 1 o'clock. John, I don't know why, I might be here too. You may come behind me. But certainly we would invite anybody that's got any interest to come and visit with us. You know, we're gonna go through a particular ordinance that we found that we like, and we're gonna review it, and we may move some things out and move some different things in. And our plan is whenever we get complete with this, and by the way, I hope that we're through by the end of October. I don't see us dragging this thing out very long. When we get a completed product, we'll, if you don't mind, pass it by the county attorney, and of course we'll give the judge a copy, and we'll just go from there. The things we need to go back and relook, we will, but we don't see this process dragging out for us anyway. And I know that you guys have to have public hearings and post notice and those kind of things, so we don't want to drag it out any longer than possible. That's kind of where we are up to date, and when you move to the next item, I do have some comments about that.
Well, all we had on item 5 was a report, and you've given a detailed initial report from the committee. We understand where you're going. Does the court have any questions for Mr. Roundtree before we get to their preliminary recommendation?
No, I don't have.
No, just appreciate what y'all are doing.
Yeah.
Okay, now on item 7, we had set up for item 6, the court to consider an act on an order about groundwater studies. I understand this was a recommendation and a vote from the committee.
Yes, so we asked the judge the first meeting, we wouldn't put this on the agenda, but we decided to go ahead and take a formal vote of the committee at our second meeting, and it was a unanimous recommendation that we go ahead with this particular document. We feel like if we can get this document implemented, it'll go a long way in calming a lot of the fears that a lot of us have regarding water. In a nutshell, this is a groundwater availability certification for plating. It's part of the TCEQ rules and regulations. It's chapter 230. And let me read just part of the first paragraph, and it says exactly what we feel like needs to be done, or we need to be careful about. In the plat application and approval process, municipal and county authorities may require certification that adequate groundwater is available for a proposed subdivision if groundwater under that land is to be the source of water supply. In other words, the developer has to certify, and don't get me wrong, it's a pretty detailed report that they've got to go through. They've got to hire either a professional licensed engineer or a professional licensed geoscientist to do this work. And there may be some times when the court would want to hire your expert to review the information that's given. Maybe not always, but there may be a time that you have some questions, or maybe you question what is being reported to you, then you may have to hire somebody that's your expert to review the water data. But the data is going to include, first of all, they have to determine the demand of the water to be used. And, if they've got 100 households, they've got to determine how much water those households will use in a year. And in fact, on page 9 of the document, it'll tell you that they've got to do this for, they've got to tell you over a 10-year period, and then over a 30-year period, what the drawdown will be on the aquifer. Now, there are other requirements in here which include the quality of the water. Of course, that's extremely important. Let's see, build out the subdivision, and they have to hire a licensed engineer. We plan to incorporate this document into the subdivision regulations that we finally propose to you guys. This will be a part of it, but this is something that you can take action today and will become effective in case there's a new development to come before you. Page 19 also in the document. Bill Malone brought this to my attention. I think it's a great idea. Page 19 under B, it talks about the determination of conditions of the groundwater availability. Certain assumptions are used, and it says on these bases, the engineer or the geoscientist may include, but not limited to. It didn't say they're required to. This is under B, the last sentence on page 19. It says may include, and if you look at number 1, it says you may include future pumpage from the aquifer or from interconnected aquifers from area wells outside the subdivision. Now, we can't change state law. We can't say you are required to do this. But what we'd recommend is that in your discussions, and I'm assuming each commissioner will have discussions with the developer, maybe insist or request that they take a look at the area outside the aquifer, because there may be a subdivision that's built right across the road. And so whatever groundwater they're pumping certainly would affect this subdivision as well as their subdivision in the future. Or there may be, 3 or 4 households across the way. We just wanted to see if there's some way to be able to see what the groundwater pumping would do, what effect it would have on the neighbors. We certainly want to have water for the new residents as well as the old residents, and we feel like this is one way to hopefully protect our water supply. We also ask that you consider whatever verbiage, I guess it has to come from Gerald, is necessary to put the results or some note on the plat regarding water availability. But the plat is going to follow everywhere the transaction is made or wherever a sale is made. Put that note on the plat to refer to the water availability study that has been done. We've all looked at a number of subdivision ordinances throughout the state, and compared them, and the ones I've looked at, and I think the ones these guys have looked at too, all of them require this. Hamilton County requires it. So whenever the subdivision was built in Hamilton County, they had to adhere to this. But when they jumped over the line, they didn't have to. San Saba County requires it. McCullough County, Barnett, Palmetto, Bell, all the ones I've looked at require this type of certification, or requires to the rules that have been set up by TCEQ and administered through the Texas Water Development Board. So this won't be anything new to developers who do work throughout the state. It's just something we think, we have done, and we feel like, and I'll be glad to answer any questions, or if any of you guys, I'm sure Chet Johnson has something to say.
You did a good job.
Any questions?
Yes, I do. Hamilton County may have it on their books. They're not really requiring anything.
Well, that may be true.
Yeah.
That's not anything we can do.
But
Really about.
the one out there by us is split. The 1,000-acre place, half of it's in Hamilton County, half of it's in Mills. The only thing they did do, they drilled at 3 wells. One of them being in Hamilton County, one of them being in Mills County. And one well they didn't get drilled because they had void. And that was their proof, of water. Now, I have talked to a guy, I said, is this 10, 20, and 30-year deal even a doable deal? And he said, yes, that they have laser means of measuring the water aquifer. I don't, but that would all go back onto the developer's expense,
Well, I would hope you guys, as Mills County Commissioners, are more diligent than Hamilton County Commissioners, if indeed they did enforce this.
Yeah.
It's not enforcing to do this good.
That's exactly right with any of it.
And we've talked a little bit about specificity of the document. Some of the ordinances are a little more general, and we feel like the more information that we put in this thing that'll clarify it for you, not only y'all, because let's face it, y'all change, and the developers change. But something that you can pick it up and read it without having to refer to this rule and TCEQ would be a better document than one that's really general.
Yeah.
So, I can't speak to what Hamilton County, I just know what's in their ordinance.
Yeah.
All right, any other questions from the court?
We would recommend approval, of this document.
That was a unanimous vote, as I recall, right? And just for the court's benefit, what the section 232.00.0032A of the government code says is basically it authorizes the commissioner's court to require a subdivision for which the source of water supply is intended to be groundwater, to attach a statement to the plat that's prepared by an engineer and certifies that adequate groundwater is available for the subdivision, and that certification meets standards set by the Texas Commission on Environmental Quality. So we have to have an order to that effect. There's a draft order included in your package for approval. All of the details that Mr. Roundtree mentioned are germane, and that section 230 of the TCEQ regulations, which he referred to, is the current status of what TCEQ requires to make such a statement. But those things change. They're not negotiable to us. All we can do is require a licensed engineer or geoscientist to have a certification with the plat that meets the TCEQ standards. So that is then this is separate from a subdivision ordinance. We still need to address that through the public hearing and rest of that process. But this is just an action that a county can take to adopt. As Mr. Roundtree pointed out, other counties have adopted it. As Commissioner Parkin pointed out, that's half a loaf. You have to enforce it, but you can't enforce it if you don't adopt it. So I move the court adopt the order requiring groundwater certification with certain plats.
A question maybe for Gerald. If we do this, this can be enforced without it being on the subdivision regulations.
Yeah, I think so. I mean, it's a separate action that the county can take. And I don't see that it has, I mean, obviously, we're in the process of developing new regulations, and this will be a part of the new regulations, but I don't see that there's a problem for the court to take this action today, which in effect amends the current regulations that we have.
Okay.
It would make it a part of the existing regulation. I might, logistically, I think what the TCEQ has a promulgated form that they issue whenever you file a report with the TCEQ, and they send it back to the developer, and I would anticipate that form, that certificate would physically be attached to the plat that's filed in the clerk's office as far as how you document that they went through that procedure, and the certificate would be attached to the plat, and the plat is submitted to the commissioner for approval. I mean, these plats are going to be submitted, and of course, for approval or disapproval, or this is just be a part of that process. Bobby did say something about aquifers. To my knowledge, there is no aquifer in Ems County. Aquifers have completely different rules. We're familiar with the Edward aquifer, which is what's practiced in Bear County and beyond. I think, though that's a completely different animal. So I don't think the rules regarding aquifers have any problem. We have what's called percolating water. An aquifer is like an underground lake. Mills County has what's called percolating water, which means it just oozes around underneath the ground somewhere.
I thought deep enough in Mills County, we were into the Trinity Aquifer. That's what.
That was my understanding.
That's, you know, when somebody drills a well, if they go deep enough, 350 feet plus, the well drillers will say, well, you're into the Trinity.
I don't know.
The other is just water veins. I mean, we've got some wells 125 feet deep that are just shallow water veins, you know. But, I don't know. That's another question for somebody else. I just want to make sure that we could either attach this or this could be separate.
I think we can do it.
I second the motion, Judge.
Okay, we have a motion and we have a second. Do we have any further discussion? All in favor, say aye. Aye. Any opposed? Okay, the court's unanimously approved this order. We will sign it, attest it, run it through the clerk's office and post it to our website, and it will be enforced today for plats filed from today forward. So other action items on the agenda, and want to thank the members of the advisory committee. I will see you tomorrow. Appreciate your work. Yeah, 1 o'clock in this courtroom. And if you're welcome to stay and watch the sausage making, but at the same time, if you got rats to kill, we appreciate it.
And by the way, we don't purport to be water experts. We just know what water is and we see it.
Okay. Moving right along, number 4. We prepare these agendas pretty far in advance, and 4 is consider an act on policy for off-duty use of county vehicles by law enforcement and possible action on payments for past use. I thought after the last meeting, we were going to have a consensus draft of something between myself and the sheriff's office. What you We don't. What we have in the package is a draft I prepared and shared with the chief deputy of county policy and procedure. Some of the basics are county equipment's not to be used outside of the county in conjunction with outside employment. That doesn't mean it can't go out of the county on, public law enforcement use, but for off-duty work, it stays in the county. And that, let's see, recognize that there's a public purpose in providing traffic control in construction zones in the county. That puts it under the appropriate public use authorized by the sheriff. It states that sheriff's deputies would be paid for off-duty work directly by the hiring contractor on whatever terms and agreements they negotiate, subject to approval by the sheriff, and that the county vehicle the county would be reimbursed for the county vehicle through the county, directly between the county and the contractor. And then attached to accompanying that is an example of one such agreement currently used in Travis County. And it shows, it's signed by the contractor, it's signed by the county, it's job specific, and it's basically specifies they pay the deputy and they will make a donation to the county based on an hourly rate for the use of the county vehicle. So that's one approach. That's what I put together. Then Chief Deputy Green sent back, and I've got it in here, an email and some existing policy. Basically, the email says we will not use county vehicles for out-of-county traffic control off-duty. And Deputy Green can correct me, I'm paraphrasing pretty broadly. And then there's a departmental policy from 2015 with a more recent revision on the take-home vehicle program and the off-duty employment guidelines, as well as, and I think the court's seen this before, an attorney general opinion about the control of off-duty use of county vehicles. It basically says, unlike the rest of the county where it's illegal, improper, and illegal for, say, a road hand to take the backhoe home and work for a septic contractor to put in a septic system on its own time. Law enforcement can do this off-duty when the sheriff deems it's in the best interest of public safety in the county. So, and that also he has sole control over that. So I think it also says that the highway contractor cannot pay for the use of the vehicle because that's a lease of a county asset. So it has to be a donation. That's why that convoluted step exists. So that's my legal summary of the Attorney General's opinion. And then there's a local government code section on acceptance of donations, which I think you're all familiar with. Chief Deputy Green, would you like to add or correct to that?
No, you got it down pretty good from what I can understand. It's, the parts that pertain to the sheriff's office in particular, I thought remained, but it's the use of the donation for use of the county vehicle and things like that. That's completely separate than what we would do. That's up to the commissioner's court, totally. So.
And are we in mutual agreement on the out-of-county traffic control, off-duty traffic control?
Yeah. Rather than there is, it's there again, you're dealing with state government, so not everything is crystal clear. You've got to, suppose out of many different statutes, but there are some arguments that, it's proper, this, and that, and the other. There are some that it's not. There again, some of the ways the counties have gotten around that is for the donation. So, but for instance, when we've done it several years ago, Lab Pass has had some bad issues. A lot of their offers, we're going to be offered a funeral, things like that. We'll go assist them taking some calls, things like that for them. Obviously, we'll have a patrol unit, things like that. But those are legitimate public,
Yeah, that's under like your mutual
Correct,
assistance
correct.
agreements, yeah.
Mutual aid thing. So, but other than that, no, we, just to save the argument, just to save, basically any misunderstanding, that we're just not gonna do it. So.
Mr. Hale, is there anything you would like to add or expand
Yeah,
on?
I like the idea of having a policy. So, fine with me. And if you need it, and apparently it is clear, this has nothing to do with the situation where deputies end up having to go to another county for
No,
normal
Right.
police activity, whatever it might be. It's just when a third party contractor is hiring
Correct.
an off-duty
Correct.
deputy and using.
And I just wanted to clarify that because sometimes we do take people out of county, whether it be for investigations or to help another agency.
It happens all the time, so, yeah.
But just not for off-duty activities.
I still don't like using the word donation. I don't think it is an AG opinion. I disagree with it.
And
It's
And I'm not
funny.
gonna get over that. So.
Yeah, it's floating out there.
Yeah, it's, that's what a lot of the other counties use, and that's entirely up to y'all. I mean, but that's kind of where we're at on that, so.
well, Court, I think Chief Deputy Green and I have served it up to y'all. So now it's, what do we want to do?
I do think it's great that we have an established policy.
Yeah.
Good idea to have it done in place.
And that was good to see that it is required that the deputies know that the contracting agency is covered, make sure they have insurance and all that. It says that in that policy to make sure they're covered.
Right.
Because that was one of the questions I had last week, who's covered if something happens?
Right.
And so it's stating that contractor should have all that information. I'd make sure that you had that.
Well, 99.9% of the time, if we're doing something of that nature, it's through an established company, contractors, things like that. It's not, we still work on off-duty security around town. We used to work it out at the Pretty Dance. We occasionally still do. We did work for the fundraiser down here for
The town of Brooklyn.
yeah. We do things like that. We still around the area, we still do that, but and that's for individuals. So we're not necessarily, requiring liability insurance and all that, but anything that's established with a company or something like that, obviously, they're going to be covered with their contractors.
But my take is this is within Mills County.
Correct.
Yeah.
Yeah.
Correct.
And so
Yeah.
it's basically, if it's the Pretty Dance or whatever,
Right.
it's part of your, can be part of your patrol anyway.
Right. And there's nothing saying we can't go outside the county and work security. We're just not going to do it with a county vehicle. Unless y'all provide for some sort of relief for that. So, but that's entirely up to y'all. So.
Personally think it needs to be within the county.
Yeah, I agree with that.
Yeah, I mean, and a lot of the road security thing is a big thing. There become a number of companies that are helping with this and have popped up all of a sudden. But all they want is a marked unit that they don't narrow it down a whole lot further than that. So we can get magnetic stickers and put it on an old car with some lights on it. That's all they care about.
Well, like I told you, on 36, there wasn't anybody
Yeah.
emailing units. It was just a flashing light.
Correct, correct. They want the car. They just usually can't have the car without the operator.
Well, driver.
So what do we need to do here today, Judge?
Well, I mean, one thing we could do, let me get my papers unshuffled, would be, I think we can adopt the policy as drafted, and it's not inconsistent with everything we're all saying. And then leave it up to obviously the sheriff's department to implement, to have a form or to check the insurance. I mean, that's all operating procedure. And as the deputies shown with, they have detailed policies on a number of things. It just doesn't quite get off into this specific issue. I mean, for instance, this policy says, number one, the off-duty employment of deputies must be approved in advance by the sheriff. That's already in the departmental policy. It says deputies will be paid for off-duty work by the hiring contractor, blah, blah, blah. I think that's in there. And if it's not, it's consistent with the understanding. And the third one is the use of county-owned vehicle for traffic control is limited to Mill County use. That's what we're all saying by agreement, and requires a separate agreement between the contractor and the county. And that's, there's an example here from Travis County, but if they want to do something else, that's fine. So I think us adopting the policy, the sheriff's is what I'd propose to do. I think it's as close to mutual agreement as anything we ever do. And there's some documentation and operational procedures that will, be the sheriff's to implement. Yeah.
So basically, it's already.
Yeah, we just need to.
It's just not a
clarify.
county,
We just need to say it's a county.
Within the county.
Within the county.
yeah, right, which is what this does.
Okay.
So, and the sheriff's department's in it, the sheriff's office is in agreement with that. And our county attorney is advised that it would be his preference to have a county policy on it. So here we are. So, okay.
You want to make a motion? And you want-
Yeah, I'll make it. Move adoption of Mills County policy and procedure on the use of county-owned vehicles by off-duty law enforcement personnel working for hire. Is there a second?
Second.
Okay, we have a motion and a second. Any further discussion? All in favor, say aye. Aye. Any opposed? Okay, the last action item on the agenda is number 7.
Judge, did we deal with the past payment?
We did not.
I'm sorry, I didn't hear what you said.
Well, it's included on this agenda item, adopt a policy having to do with the use of vehicles in the future, but also dealing with the past payment that we have kind of hanging in limbo right now.
Well, my thinking would be to accept the donations that were proposed. What was it
That's
2 meetings ago?
correct. That's the way we're going.
Yeah.
And I thought it was handled that way because I had to close out my book.
Okay.
And so there's no going back and changing it at this point. That year is shut down. Done with.
Subject to audit.
There's no-
Subject to audit. So then I'm going to add to the motion.
Well, let's just start a new
Yeah,
motion.
that's what I'm saying. I make a motion that we, let's see here, how I want to say this. That the payment of past use be accepted as already written in previous courts.
Let's say that the donations for prior off-duty use of county vehicles previously proposed by the sheriff's department be accepted.
So that's so moved. I'll second it.
Okay, we have a motion second. All in favor, say aye. Aye. That cover the loose ends? Okay, now another loose end is our county clerk, or at least scrap equipment number 7. No, not the clerk. It's the stuff that she's accumulated.
I didn't accumulate it, the room accumulated.
Okay.
From my understanding is all this equipment on this declared scrap list has already been declared as surplus in the past.
Yes, this list of 21 items has been declared surplus, but the passage of time and technology has made some of this unusable.
I mean, if anyone wants to go through it, fix it. I mean, some of them are kind of half broke. It will say like the printer doesn't work, but the scanner does. Or vice versa, or they're so, I mean, they technically, yes, it will still work. But the technology part of it, whether the drivers are still gonna match what's on the laptops and the current computer systems, they're, will they work? Technically, yes. Are they so out of date that they're going to be useful? I mean, I'm not the technology person to give that, but they've been down in that room since I was here in 2019. And
Yeah,
just,
and these are from all different
yes.
Yes.
from all different-
offices.
Yes, the JP's office, the treasurer's office, and then before Ms. Campbell was in,
Sheriff's office.
sheriff's office. And so they've been available to anyone that's wanted them, and we have, some pieces have been reassigned to other areas. And sometimes we've declared things and someone's gone, oh, hey, I could always use an extra printer that works, and if that one's compatible, I'll take it. And they have. So the stuff that's left is either not compatible with what we're using or nobody wants. We need to do something.
I make a motion that we declare the list of 21 items as scrapped items from the courthouse basement that was previously designed as surplus to be destroyed.
I'll second it.
Okay, we have a motion and a second. All in favor, say aye. Aye. Any opposed? Okay, now let's go back and go through our departmental reports. This is for the month of September, which was both the end of the quarter and the end of the county's fiscal year. So there are a few more reports, mostly from the treasurer. From the treasurer, we have a monthly report, a quarterly report, and a quarterly investment report. Ms. Campbell, is there anything you would like to point out in any of these? I'd point to the investment report, got CD balances of $2,436,000 at the end of the quarter or the end of the year. And that has run down. We're in the time of the year when we are, the cash flow is slowed down on the input side. It'll pick up again in December with taxes. So this is typical to see our investments run down in this last quarter of the year. Let's see, accounts payable. This was distributed electronically Friday. Any questions from commissioners?
I've got a couple. I think they're all deal with the sheriff's department. One, agro fuel that you got out of San Saba. The big, do y'all have a storage tank now? Generator. Gotcha, that's where. Sorry, gotcha. And then there's a conference expense down there. Are those all the same conference? No, Ms. Summer. It's on page 8.
I just have a
That's
general.
probably
One says jail conference, the other one just says conference, but if they're all together, that, I mean, it blew the budget. It blew the budget, so that's what I was trying to figure out. Because they're all under conference. Okay, and then we're reimbursing a deputy for tags on a vehicle. Don't understand.
How
why
much
the
is
deputy-
it? How much is it?
It's $7.50, but I just didn't understand why the deputy's buying tags.
Pages that I'm fixing.
Page 9. It's just something that we hardly ever, I mean, I don't guess I've ever seen where somebody's buying tags. It says reimbursement, so
I have to go back downstairs and look. Julia did these on Thursday and Friday.
Yeah, let's see if we pay, I mean, normally, obviously, we pay that from the county to the tax assessor collector. Unless there was some reason that the deputy had to pay it out of pocket. Okay,
I think it was just the way the expense ticket was written up. When I glanced at it on Friday, I think it's just the way the expense request is written up that may have been confusing. But I'll double look it.
okay. That's all the questions that I had.
Commissioner Parker, did you have any
The only
questions?
thing I had, me and Jason talked about, these $2,500 and 5,000. He said that was a yearly deal to the Mills County Soil, Water, and Mills County Historical Commission.
Yes, that's,
It's yearly.
yeah, it's,
What they get, basically.
yeah, it's, I think it's in our public service budget, is what it's called, or
Yeah.
community organization. And on the soil and water conservation district, that's our share of basically the flood control dam maintenance. Okay, moving along, the appraisal district monthly report. This is for the county's fiscal year end. You can see on the county taxes, there are $16,175 of unpaid current year taxes and $311,000 from last year. That remains being the encore appeal. Thing to look at on the bottom of the page, there's collection rate against the adjusted tax rolls, and it's 99.57%. That number at year end is significant because we budget collecting 99.5% of the taxes. So this means that the tax collections covered the budgeted assumptions for the year. There's pages now of reports from the county clerk and then the district clerk. See the county clerk collections of 12,000 and the district clerk of 6333. And at the top of the page on each one, you see what drives it: recording fees, fines, a whole list of other items. And then at the bottom, you'll see whether it's paid by cash, check, credit card. The tax assessor collector report. This is item H. Collected 123,000 plus for the month, of which the county retained $18,816. We have the report from the Justice of the Peace's office. No, I'm sorry, I picked up the wrong page. This is from the Ag Extension Office. 328 miles traveled for the month, with the bulk of them, 240, being a meeting in San Angelo. You can see on the second page the upcoming plans, which are largely livestock validations. And then on the last page, some of the discussion items. The sheriff's office report for the month of September is the next one. Total calls through 911, I believe. This is 291 for the month. 53 of those are, that's about 20%, are EMS related. 208 are law enforcement or sheriff. Then you see smaller numbers for fire and DPS and game warden. Thing to look at is arrest of 11, new jail bookings of 26. The difference is jail bookings from somewhere else. And at the bottom of the page, you'll see the out-of-county jail billings. That 29,400 for the month is substantially above our usual, and Coryell County being 21,000 of it. The Justice of the Peace report is multi-page. This is a state form. The way I look at it, new cases filed on line 2, that's 52 at non-parking, and other columns across the page. Total on the docket, then 929 cases resolved. That's line 10, 34. And then you see cases at the end of the month. The second page is the civil cases. You can see new claims filed with 6, that's line 2. And then cases disposed, line 13 of 1. And then an end of the case, the juvenile activity page is 0. On the last page is other activity. You can see jail magistrations, 9 class A, B, and misdemeanors and felonies, and 2 of the 9 requesting county paid attorneys. It shows 1 inquest for the month. And at the bottom of the page, collections, 12,163, with 8,100 of that being retained by the county. Judge's office report sold $50 worth of books for the historical commission. Senior center utilization, but not much senior center income. That tells you, I mean, our practice is we have not been charging for nonprofits. So this tends to be churches, library, Lions Club, things like that are nonprofits, or most of our use. Septic tank permits remain active with 4 for the month, and total of almost $7,500 of septic fee income for the year. Have our monthly EMS reports for both Mills County and the city of Gulfway, with average response times in the city of 3 minutes, 3.5 minutes, and in the county, 11.5 minutes. And it looks like there was a period around September 24th when we had some calls going longer than that, out above 20 minutes. Let's see, that Wesley Alexander from the EMS service is on Zoom if the court had any questions for him. Then there's a report from the Veteran Service Officer, a list of activity in the month, total of, on the right-hand side, number of veterans served, and worked on cases for 23, assisting 23 veterans, spent 40 hours doing it. So that's the consent agenda. I would move approval of the consent agenda.
Second.
Just a little leap on the reimbursing the deputy. Julia's texting me, I guess she's listening. She's saying that son did in fact pay for his own. He didn't want to wait for the process to go through court and be out of tag for however many weeks it was. And is asking to be reimbursed.
Okay, I mean, it's just $7, but
Yeah.
I'm just curious why you went into that process. Gotcha.
Okay, so we have a motion and a second to accept the consent agenda. All in favor, say aye. Aye. Any opposed? Okay, so we've covered the consent agenda. We've covered the action agenda. We're down to number 8, commissioners' requests and reports. Commissioner Parkman, since precincts 1 and 2 seem to be
Or he comes up
Yeah.
next.
kind of quiet.
Been hauling some base on pile 17, kind of got that completed. Been hauling a lot of base. Supposed to get the transmission back in the other maintainer sometime this week. I haven't got a call. They said Monday or Tuesday it'll be here. So if we can get things back up and running, we got a little moisture in the roads now. We're trying to blade, but we're down to 1 maintainer, so it's limited. I guess reports is got a call the other day. I called the sheriff's department. Hopefully they can patrol it. There's a section of road right past Democrat going towards Zephyr that the guy's picking up trash, and he's picking up a lot of trash. And it's basically the either Blattner or Vestas people that are coming through there early in the mornings, driving like crazy, coming back too late in the evenings, and they really are driving too fast. They're running people off the road.
Is this on 218?
Yes.
Okay.
The guys sent me pictures. I don't know if DPS can patrol that too.
Yeah, I talked to someone last week that they saying that would get them back.
Yeah, it needs to be under control, and it's like at 15 to 6 in the morning, and then whatever quitting time is. And I even asked my wife, I said, do you see them? And she said, God, yeah. She said 5, 6, 7 vehicles at a time, just really driving too fast and reckless. So if there's any way, I think a guy wouldn't have to sit out there. I think if you catch 2 or 3 of them, it'll slow down for a while.
Right.
Yeah. So, but the guy had a legitimate complaint because they really are. And I've heard locals say, my God, just get out of their way.
Yeah.
So it don't need to be that way. So that's I mean, it's not a very wide road anyway. Everybody needs to stay kind of on their side. Not quite as far over as Jason stays.
Yeah. You're never gonna let me do that.
But anyway, that's kind of what I got in a nutshell.
I'm kind of like with Dale, blading with the moisture and stuff we got. It's still sporadic of where the water's coming, the rain's coming, but bladed most of the roads out by 45, got all those done. So the only thing I was gonna let the court know is I'm gonna be, and I know we have a meeting tomorrow on, some other things that we were gonna meet with Judge tomorrow, but I sent in an application to go to my training in Abilene at the end of this month, and they were filled up in 3 days. They're only taking so many people. So for me to get my training, I have to go tomorrow to Round Rock and took Tuesday and Wednesday to get my training because there's only one other training in San Angelo in December. So I'm going to have to bail out on that meeting tomorrow.
Okay.
I'll visit with you afterwards on that, but I'll go to Round Rock to the 99th annual conference. And I know Mike was originally planning to do that, and then he had to back out due to sickness, but that'll be Tuesday and Wednesday. The only other thing we're going to report is that we're getting engineers and stuff to come out to do one more look through on the cameras on the swinging bridge and getting that finalization. And San Saba and I are going to meet with them and engineers, and that'll be not this week, but next week to finalize price and all that other stuff and the prep work we need to do for those camera systems on the swinging bridge. So, and no, tomorrow, no MCAD meeting. It's been canceled. So.
Okay. looking for a few good people. The Council of Governments is looking for Mills County to nominate somebody to serve on the Development District for Central Texas. That is a regional development board, does a lot of grant allocation, but and program, prioritization. In the past, the board's members have only been from Bell County with one from Milam County. They're trying to expand that to get somebody from Hamilton, Lampasas, and Mills. So if anybody knows anyone that would be interested, the biggest negative is probably one trip a month to a meeting in the Belton Colleen area. Chamber of Commerce is also recruiting locally for an executive director. County Court will meet next Wednesday here in the courtroom, so that we'll have this room tied up most of next Wednesday morning. We have a meeting with a firm that does the Christmas lights in Comanche County later, I think, in the month, to just see what they could do and would recommend around Mills County, or around the courthouse primarily. And we are expecting a report from the insurance adjuster this week on the remaining claims that supposedly the estimates are done. They have a number. They have it cleared with the a version of the buy board, so people ready to go on it, but they're withholding sharing it with us until they have tax buy off on. They will cover it 100% with insurance. So all I can say is I think we're close to something, and that's the judge's report. Is there any, if there's no further business, I'd entertain a motion.
Somebody make a motion or anything.
Okay.
Second.
We have a motion and a second. All in favor, say aye. Aye. Court is adjourned.